Well, we've discussed the importance of communication and how the court will look at to determine whether or not good communication will support a joint situation. Ideally, it will. But if one parent won't communicate with the other, the court is going to intervene. And there's going to be ordered communication tools at first. The court will require the parties to only communicate via a non-inflammatory method. So the court might not allow personal communication, but might only allow them to communicate through platforms that the courts have set up in order to facilitate peaceful communication. The court can order the use of these communication tools. But I have to tell you that if one person won't communicate, at the end of the day, they're not going to communicate properly with the communication tools either. They might be sort of totally unreachable, or they might communicate in an unproductive way. And if that's the case, guess what's going to be impacted? Child custody is going to be impacted. There will be custody consequences if the parties are not communicating appropriately. There could be parenting time changes. The court could order sanctions for somebody not doing what they're supposed to do in the way of communicating. Let me give you an example. We have two troubled parents. They can't get along. The court orders that on such and such day, a phone conference occur and initiated by wife or mother for a 10-minute discussion about what the activities are going to be coming up that weekend. If mom doesn't make the call and it doesn't occur, or dad calls mom and she is not picking up, if there is that kind of lack of communication that may involve the violation of a court order when the court intervened and ordered it, you're looking at sanctions. You're looking at one party being smacked with the attorney fees to the other side. Maybe one party will get nailed with make-up parenting time that has to be provided to the other parent. The court might order that person lose their parenting time because they won't cooperate in scheduling the other person's parenting time. So you got to remember, there are broad powers available to the court to address the situation where one parent simply won't cooperate about the child with the other parent. And it's, most of the time when there are remedies, it's because the problem has come up. The remedies are designed because the situation occurred. The court doesn't have a remedy standing by if there's never a problem. So it's commonplace that we do unfortunately see, and it's not most people, but a lot of people who simply won't cooperate about the child. And why? Because they're angry. They feel insulted. They feel slighted. They feel that they were mistreated somehow. So therefore, they're going to get back at the other parent by making the child parenting time issues more difficult. That happens, you can expect sanctions.
248